Good evening. Today is Tuesday, the 7th, and what you're seeing on the screen is not uh, it's part of what we're going to be talking about, but really what we're going to be talking about is Springer versus the 7th Judicial District Court. Over the weekend, excuse me, over the weekend, I didn't know. I don't subscribe to him, and I don't watch his content, so I didn't know. My apologies. His will probably be more entertaining than mine because it just will be. But we already discussed the first motion to amend correct. He raised this particular case from the Fifth Circuit, and it didn't look right. I didn't understand it, and so, well, I didn't really go over it much. It is a long, very long decision. This is 74 pages. 74 pages. But yeah. But anyway, today they filed a second motion for temporary restraining order and preliminary injunction. And I had an opportunity today to glance at it. And they raised the same stuff again. So I guess where we should start is we should start here. If at first you don't succeed, try again. This attorney is doing the Chile de Castro version of advocacy. I think it's still probably the Zach Cook guy who's oh no, who's the other guy? There we go. I think it's this guy who's writing it. It's already been brought in. Nice. It's fucking funny as hell. What's his name? Coded has decided that he can annoy me by in like Stone Vet streams. He'll just tag me, right? And so I'm like, I wonder what would happen if I blocked him and he couldn't tag me anymore. I wonder if that would piss him off. Apparently, it pissed him way the fuck off, which is hilarious to me. So yeah, and this is kind of lawyering. I did get a new noise reducing microphone for my phone. I'm thinking I might make a new fishy channel just for my fishy stuff, because I don't think that my core audience has any real issue or interest in visuals. So I don't want to bore everybody with it, even though it is probably my second greatest passion. Nice. Anyway, yeah, so I might start a new channel now that I have that, and I can go in there and I'll actually record videos instead of trying to live stream, where it gets very shitty quality, picture quality and sound quality. Yeah. Surprisingly enough, Dave. Surprisingly enough, it is. Except they found the case, Dave. We're going to go over that. This is the case. This is their win, right? This is their win. Well, I hope Orange Cones. I appreciate you being a core audience. I hope that those people who are interested in my vigi content, which I won't make much because I spend more time in there just chilling than thinking about, I want to share this with everybody. But the people who will be interested in it will go over there. The people who won't, right? So let's start off. Let's get it. One other thing. I did a live stream with Rogue Nation. I was very polite and I was not mean at all to Mr. Rogue Nation. And Oh, that's interesting. I did not know that, Nate. But I'm sure if I do make a new channel, you will be more than welcome to go to the new channel to see fishy content. But anyway, in the live stream I did with Rogue Nation, we were debating, and I guess we could only really loosely call it a debate because he didn't really understand much about it, and he was just reading from a brief. And I was drinking. I did have an adult beverage, a 9.5% beer, which is a lot for me. But we were discussing Price versus why did I just blank? Gardner? I forget the name of it, but Price. And he asked me after we had finished basically debating it. He was asking me about content neutral restrictions and why the city hall in North Carolina and in Florida can have restrictions on filming employees without that being a content-based restriction. And the beer got to me or whatever, and I blanked. Maybe it was the way he asked me the question. I don't know exactly why, but I completely just like, I don't know. I remembered there was a case out there that dealt with it. I remember that it dealt with it in such a way as to get around the issue, i.e. the court had found that it was not a problem. And I completely missed the most basic step. And it just snapped to me at about 3:00 this morning that the City Hall is a limited public forum. And there's really two tests. There's really only two tests. There's 4 kinds of forums, and there's 2 real tests. And the designated public forum and the traditional public forum, they have the same test. If it's a content-based restriction, it's strict scrutiny. Otherwise, it can be subject to reasonable time, place, and manner restrictions, right? And then the limited public forum and the non-public forum have the same test, and that it has to be reasonable and viewpoint neutral. So you can have a content-based restriction in a limited or a non-public forum. The city halls are most likely limited public forums. They may be non-public forums. Areas of them might be designated public forums. Even smaller areas of them might be traditional public forums. But the parts where the employees are likely to be areas where it is a limited or a non-public forum, and therefore you don't have to worry about the issue of the content-based exemption, content-based restriction. So if you had watched that and you were left thinking, why the hell, what's John thinking? Well, that's the actual answer. Content-based restrictions are A-okay in limited and non-public forums. So now to the motion at hand. This is, once again, Springer versus the 7th Judicial District Court. This is plaintiff's opposed second motion for temporary restraining order and preliminary injunction. Counsel for defendants has been consulted and does oppose amendment of the complaint. Well, guess what, fellas? This is not an amendment to the complaint. This is another fucking case, just right off the bat. In the title, in the footnote to the title, you can see that this motherfucker didn't read a goddamn thing. He left the same footnote in there, and the footnote is for the motion to amend the complaint that we went over on Saturday. You know what? I am going to show it. This is the motion to amend, correct the complaint. This is it. There's the footnote up there, and there's the exact language. Unfucking believable. Unbelievable. Comes now, plaintiff, through undersigned counsel of record, and respectfully moves this court for temporary restraining order and preliminary injunction to enjoin the defendants from taking any action to suppress, block, or in any sense, or in any what? I don't know. You don't know. The court doesn't know. But in any censor plaintiff's publication of material as a member of the press or citizen engaged in expressive speech or conduct on any platform. That's fucking crazy. I'm going to get upset. I really should have had a beer before I came out here because this is just going to upset the shit out of me. Introduction. The judicial branch, federal or state, is not a super branch of the government. You know, I'm sure that when Freeman read this, Freeman thought that this was good shit. But the court knows what the court is and knows what the court isn't. If you're going to talk to the court like the court is a kindergarten class, you're actually wrong, Derek Elliott. You're completely fucking wrong. And I've gone over that particular case. It was for the purpose of a specific statute. You have to meet a specific statutory definition. And the Washington Supreme Court case limited its holding to the facts before it, to the statute before it, to interpreting the statute before it. And you should stop spreading shit you don't know. You're fucking wrong and retarded, and you should stop. Fucking idiot. Dumb shit. Duh! Citizens aren't the press. Per Washington, circa 2021. I'm fucking stupid. Look at how stupid I am. Duh! It said YouTubers aren't the press. Duh! Fuck out of here, dude. They enjoy no special status in our tripartite government. I'm going to use big words because I'm fucking amazing. But operate as co-equal branch. Co-equal branches? I don't know. Why fucking spell check? Subject to the same limitations against depriving citizens of rights protected under the Bill of Rights for the United States and New Mexico constitutions. Well, the big thing is that the judicial branch gets to determine what those rights are. What have I done with MERB? I've done the same thing as always, Angel for Animals. I don't like stupid shit. I don't like stupid shit. And dumb fucks come into a lawyer's channel who's literally dealt with this case, who's explained the case in detail, just to post this stupid shit. Like, you're fucking dumb. You're fucking dumb. According to Coded, I get really mean when I've had bourbon, so maybe just blame it on the bourbon. Neither the federal nor state constitutions, as part of the limited enumerated powers granted to the judicial branches, respectively, grant the judicial branch the authority to curb rights, limit freedom, or punish expression of citizens simply because the content angers the judicial branch. The conduct violates rules or policies. Oh, go cry about it, dude. Go cry about it. Bullshit. Go cry about it. I'm not lawyering right now, dude. I'm donating my time to teach idiots like you who apparently are incapable of learning. Like, if I hadn't made a video specifically on it, you come in there with this non sequitur. Citizens aren't press. Fucking idiot. I don't care. I don't care. I don't care. Go concern troll somewhere else, Angel for Animals. If you don't like it, leave. The conduct violates rules or policies on the conduct simply isn't as polite as the judicial branch desires. While it may be in vogue as part of wokeism to censor or punish speech or conduct that those in political power, here judges, find offensive or disruptive, that type of behavior is antithetical to our constitutions and the spirit of our republic. Well, then you should have fucking thought, dude. You should have thought. Like, why are you coming in here and making legal statements, bro? Especially wrong ones. Like, the whole point of my channel, bro, is to try to educate people about what the actual law is, and not all the stupid shit that gets slung around on half-wits YouTube channels. That's literally, and you right now, sir, or at least you were a few minutes ago, you were one of the half-wits slinging stupid shit around. I didn't say you couldn't be wrong. I said you were wrong and you were stupid and you should feel bad. Yeah, I mean, there is no special right of access to the press. The people have the same rights as the press, although states may grant the press extra rights. They don't have to. Whatever. In fact, here, the defendants believe it to be the case that the constitutions permit them to strip away rights without procedural due process. All of this is just writing a novel. So the way this should read, for those of you who don't know, the way this should read is, here's what we're asking for. Here's the introduction. I'm asking you, court, for this relief. Here are the facts. Here's the law. Here's how you apply the facts to the law. End. Oh, I know. Springer's fucking 3 attorneys. Between all 3 of them, can't write a fucking motion. This is fucking terrible. So right now, instead of doing, here's what we're asking for, here are the facts, here's the law, here's the application of the facts to the law, and here's again what we're asking for, and why, and this is, you should grant it, right? Instead of doing that, he's writing a novel. In fact, here the defendants believe it to be the case. The constitutions permit them to strip away rights without procedural due process, with no regard for the limitations that substantive due process requires. They follow in depriving a citizen of rights and act in a purely retaliatory fashion for conduct they have deemed offensive. Can this court imagine our founders having escaped the despotism of the King of England, who decreed that he was above criticism from the colonists, envisioned that our Constitution would permit a oligarchy, not an oligarchy, a oligarchy comprised of judges to decide that they were banning people from public halls, from public hearings indefinitely, or threatening them with jail because a citizen encouraged other citizens to petition for the redress of grievances that they had with the actions of the judiciary? Oh my fucking God. Wow, must be a live stream. Must have been on a live stream. Done a lot of live streams. Let's see. Do phenomena. Do 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 do. Do 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 do. Do 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 do. Do 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 do. Do 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 do. All right. So it is the very first case covered in that live stream. The very first case covered in that live stream. The case is Green versus Pierce County. I haven't heard of a lot of people. He's got way more subscribers than I do, so he is a more popular channel, but I just never heard of him. RCW 5.68.010 defines news media as any newspaper, magazine, or other periodical, book publisher, news agency, wire service, radio or television station or network, cable or satellite station or network, or audio or audiovisual production company, or any entity that is in the regular business of news gathering and disseminating news or information to the public by any means, including but not limited to print, broadcast, photographic, mechanical, internet, or electronic distribution. Now, what the court determined in this case was that for the purposes of this statute, with this definition of what news media is, that Liberty's Champion is not an entity. Essentially, because Liberty's Champion is Brian Green, and he's not Liberty's Champion LLC, he's not an entity. Now, I disagree with their particular holding there, but okay, it's not a big deal. We can take a look at the statutes, see what was going on. Liberty's Champion was trying to get some information. He got arrested trying to go into some public building that required him to submit to a search of his bag before he entered. And he declined, but still insisted that he go in there. And so then after he demanded various bits of information about the employees. And part of this particular statute, RCW, that's I don't know what RCW is. Something Code of Washington? I don't know. Photographs and month and year of birth in the personnel files of employees or volunteers of public agency, including employees and workers of criminal justice agencies as defined in this statute. The news media, as defined in this statute, shall have access to photographs and full date of birth. For the purposes of this subsection, news media does not include any person or organization of persons in the custody of a criminal justice agency as defined in law. So the news media, as defined in RCW. All right. So thank you, Mr. Elliott, for being gracious. I appreciate it. I do hope that in the future you don't give out legal advice, especially not terrible legal advice. So back to the subject at hand. This particular sentence is terrible. Can this court actually envision that it is consistent with the constitutions that a person exercising their rights of press and speech should be subject to the threat of jailing or to have their publication censored at the request of the government that is being criticized in this country? Rather, the defendant's actions demonstrate the type of despotic conduct warned against by Thomas Jefferson, stating that the opinion which gives the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislature and executive also in their spheres, would make the judiciary a despotic branch. So there was pre-Marbury versus Madison, there was a question about who got to determine what the laws meant, because that's a lot of power to determine what the laws mean. And if you can determine what the laws mean, you basically can do just about whatever the fuck you want, right? And so the legislature is like, we write the laws, we should get to interpret what they mean because we write them. And the president was, wait a minute, I enforce the laws, so I should get to determine what it means. And the courts are like, well, we have to figure out whether or not someone violated the law or whether or not someone has a right that is being stripped away from them by a law, etc. And in order to do that, we have to interpret the law. And so it's us. We get to do it. And that was Marbury versus Madison. And so this particular letter is something they're citing as a source, and it's available at this particular HTM at etext.lib.virginia.edu. I wonder if that's even a good. I'm going to take out the space since there we go. So Control X, share the tab instead, and we're going to go to Control V. We're going to hit enter. See what we get. Huh. That's a little scary, isn't it? That's a little scary. I'm not going there. I'm not going there. Where are you trying to send the courts, boys? Where are you trying to send the courts? Likewise, Robert Yates, who is also not a case It's not stare decisis. Writing in Brutus in the Anti-Federalist Papers number 11. This guy is writing this like a sob sit. This guy's literally writing this like a sob sit. What you're supposed to cite are, number one, cases that support your interpretation. Number two, constitutions. Number three, statutes. Number four, learned treatises like practice guides. Practice guides would probably be higher than just like law review articles, but then like law review articles. What they're quoting here as a basis for their motion, where they need to be arguing facts and procedure like law. Instead, they're using things in political papers. The Anti-Federalist Papers are political papers. They're political propaganda. Whether you agree with them or disagree with them, it's political propaganda. Just because I call it propaganda doesn't necessarily mean it's bad. It is, but it is designed to influence people's political viewpoints. So Robert Yates warned against this, stating the real effect of this system of government will therefore be brought home to the feelings of the people through the medium of the judicial power. It is, moreover, of great importance to examine with care the nature and extent of the judicial power, because those who are to be invested with it are to be placed in a situation altogether unprecedented in a free country. They are to be rendered totally independent, both of the people and the legislature, both with respect to their offices and salaries. No errors they may commit can be corrected by any power above them, if any such power there be, nor can they be removed from office for making ever so many erroneous adjudications. And boy, how well did this stand to the test of time? Because judges have been removed. Judges can get impeached like a president can. There's literally language in the Constitution that states when a federal judge can be impeached. State judges, typically elected. Your state might vary. Many states, maybe not all, many states elect their judges. So yeah. And then what happens if the courts interpret a law in the way that the legislative body doesn't like? Well, the legislative body goes back and rewrites the law. There have been multiple instances where the court has interpreted a statute in a way that the legislative body doesn't like, and then they go and I remember there was one statute in California that was specifically like, we are writing this. The statute contains like we're writing this because the holding in this particular case was wrong, and we want a different result. And so this is the intention of this statute, is to get a different result. And if you have to go back to the 1800s to political documents, political propaganda from the 1800s, yeah, I mean he's arguing like a sovereign citizen. Next thing you know, he's going to be talking about like God's law, natural law, all the dumb shits, right? When the courts will have a precedent before them of a court which extended its jurisdiction in opposition to an act of legislation, is it not to be expected that they will extend theirs, especially when there's nothing in the Constitution expressly against it, and they are authorized to construe its meaning and are not under any control? This power in the judicial will enable them to mold the government into almost any shape they please. Except the men with guns are controlled by the president, and the purse strings are controlled by Congress. And if you don't have money and you don't have men with guns, it's really, really hard to take control over a government. But if you have both money and men with guns, it gets a lot simpler. It is incumbent upon this court, therefore, in consideration of this motion, to refrain from providing any deference to these defendants, because the branch of government, of state government, that they occupy. Well, again, this court has already said that it has not granted them any deference. So, I mean, they're just literally like spitting into the court's face. Such deference towards the rules or policies of the defendants beyond the scrutiny that would be exhibited towards the rules or policies of the other branches to allow it to provide justification for deprivations of rights is wholly improper and external to the facts or circumstances of the case. And you know what I wonder? I wonder why they didn't appeal the there's a case number that to those administrative orders. Why didn't they appeal? I'm sure that New Mexico has courts of appeal. I wonder if the defendants should have brought not demurred, but brought a 12b6 on the basis that the proper cause of action to challenge the holding of a state court is to file an appeal to that state court of appeals. They're trying to review I don't know. I'd have to look into that. And to be clear, there are procedures, rules, and laws that provide adequate protections for the function of the state courts. And you could also appeal, which is, something that you could do in a state court. Specifically authorized in a manner that is consistent with constitutions. It is called contempt. Underline. Thank you for telling the court about the contempt. I'm sure the court had no idea what contempt is. That is the only justified and authorized procedure by which a state district court that is acting in accordance with due process can address its concerns that the conduct or speech of a citizen has exceeded the boundaries of what is protected under the constitutions. Well, that's funny. I've seen a lot of restraining orders issued by state courts, many of which contain like restrictions on contacting, for example, someone, or speaking to them, or going within 100 feet of them or 100 yards of them. There's lots of I mean, that's a pretty well accepted power of the courts, is to issue injunctive relief, like restraining orders. So I don't know why, and there's no citation here, right? He's making a legal argument without any citation. All of his citations so far have been to like the Federalist Papers and the Anti-Federalist Papers. We got to get down to page 4 before we get our first citation to any court. I guess technically, if he says the constitutions of the state and the federal government, I mean, technically maybe you could construe that to be a citation, but it's a fairly weak one because cases are really what you want to be citing. Instead, here, defendants have not followed that due process to address the concerns that this court's ruling shows apparent sympathy towards. They're not letting this bone go. They're dogs that aren't letting the bone go. Because it is obvious that plaintiff has not engaged in the conduct that is actionable as contempt. Well, then it's a really good thing that they didn't arraign him or charge him with contempt or anything like that. Is New Mexico the state without qualified immunity? I don't know, but that's pretty irrelevant to this because judges have judicial immunity. So I don't know, don't care. And while I know there are some states, I think it's Colorado has gotten rid of qualified immunity. They got rid of the state qualified immunity. If you bring an action in federal court, qualified immunity is in federal court. It's a procedural rule in federal court. So it doesn't matter that your state doesn't have it. If you file a case in federal court where someone could plead qualified immunity, they can and will 12b6 you on qualified immunity, whether or not the state recognizes it or not. If the state gets rid of it, if you file an action in state court, then they wouldn't be able to raise qualified immunity in state court. But federal courts all have qualified immunity. All of them. Because it's like until the Supreme Court says no, then it's there. Or I guess technically, if like the legislative body passes some sort of law saying that that no more qualified immunity, and it gets signed into a law, and the president signs it off, etc., then maybe. But a state getting rid of it doesn't change anything about what the federal court does. A single unknowing violation of a rule against members of the press videoing proceedings without giving advance notice, and a single violation of ill-conceived and later discredited masking policy that the citizen criticizes to his government official enforcing that policy cannot form the basis for contempt, and therefore could not form the basis for deprivation of fundamental liberties. Yeah, but they're in federal court, number one. So there is qualified immunity in New Mexico federal court. And they're judges, so it wouldn't be qualified immunity. It would be judicial immunity. So I don't know why a violation of a rule that is later rescinded would mean that they could not get you for contempt on. Again, no citations to anything. I don't know. Undeterred, likely because of the encouragement that this court's prior rulings instill, defendants have now engaged, either themselves or acting through the employees under their control, in coercive efforts to have YouTube censor plaintiff's publications as member of the press and his expressive conduct as citizen. Maybe as a member of the press and his expressive conduct as a citizen. The Fifth Circuit has very recently criticized and upheld a preliminary injunction against very similar conduct by the Biden administration. So stop there. Again, I've already raised this before. New Mexico is 10th Circuit. So already we have a step removed. This is at best persuasive. Holding that, all right, this is their quote. To be sure, this modified injunction. Now, why is it talking about a modified injunction? Normally, what you'd be citing to is the test, the analysis the court used to determine whether or not an injunction should issue. But now they're talking about a modified injunction. That's kind of weird. Still, quote, restricts government communications not specifically targeted to a particular or to particular content posted by plaintiffs themselves. Now, why are we talking about this? Why are we talking about? I mean, allegedly, the district court in New Mexico, the 7th Judicial District Court, the defendants allegedly interfered with Freeman's YouTube channel and got a video taken down that was then restored. Why are they talking about and italicizing that the modified injunction still restricts government communications not specifically targeted to the particular content posted by plaintiffs themselves? He hasn't even alleged that the 7th Judicial District Court of New Mexico has targeted particular content posted by people other than Freeman. He hasn't alleged that. So why are they including this as part of the post? I think it's because they don't understand what they've read. To be sure, this modified injunction still restricts government communications, not specifically targeted to particular content posted by plaintiffs themselves as the officials protest. But does that not mean it is still overbroad? Why are they talking about a injunction, a modified injunction? So there was an injunction. It's been modified. It is currently in existence. We're not talking about creating an injunction. Why are we talking about it being overbroad? You haven't even argued that the court should issue this injunction, and here's the law saying why. You haven't even done that yet. And you're already posting a quote that's talking about it being overbroad, arguably. To the contrary, an injunction, quote, is not necessarily made overbroad by extending benefit or protection to persons other than prevailing parties in the lawsuit, even if it is not a class action, if such breadth is necessary to give prevailing parties the relief to which they are entitled, end quote. But again, all Freeman is asking for is to enjoin, issue a preliminary injunction or a temporary restraining order, although I don't know why he's asking for both, because at this point, it's noticed, so it's going to get treated like a preliminary injunction, so you can call it whatever the fuck you want. It's a preliminary injunction. It's not... What's the difference between a TRO and a preliminary injunction? Well, a TRO can issue without notice, ex parte. A preliminary injunction, there's got to be a hearing on it. Well, this is an opposed motion. There's going to be a hearing on it. It's not ex parte. He served it on opposing counsel. Why are we talking about TROs? I don't know. I don't fucking know. Oh. Such breadth is plainly necessary, if not inevitable here. Now he's bolded this part. He has added the emphasis here. The officials have engaged in a broad pressure campaign designed to coerce social media companies into suppressing speakers, viewpoints, and content disfavored by the government. The harms that radiate from such conduct extend far beyond just the plaintiffs. It impacts every social media user. Naturally, then, an injunction against such conduct will afford protections that extend beyond the plaintiffs, too. An injunction can benefit non-parties as long as the benefit is merely incidental. I had such a problem with this last night, or whenever the fuck I went over this. Was it Saturday or Sunday? I had such a problem with it. And why did I have a problem with it? Because they're not talking about the test. All right. So now here we go, and we're going to get stupid with a long, boring analysis, but I'm going to cut down through it. So the Biden administration was sued, and various other agencies like the Surgeon General and the Health Department and some other people were sued. And well, I was kind of going over that. So what the allegations the plaintiffs were making was that the Biden White House, the Surgeon General, the NIH, all these government agencies were either directly forcing the social media corporations to suppress, delist, modify, push down in the rankings, silence, censor. The speech. Right? So that's what the allegation was, and there was a preliminary injunction issued by the district court preventing the various agencies from doing lots of things, right? I'm trying to imitate this. No, he gets high and he laughs a lot. I'm irritated right now, and but I mean, I guess if you think I'm trying to imitate him, that's fine. I guess imitation is the most sincere form of flattery. And if you think I'm trying to imitate him, just without anybody saying anything, that means that I must be imitating him. And so it sparked that. And so you think that I'm like Josh. And I'm going to take that as a compliment because I like Josh. Angry at the chat and drinking. What am I drinking, bro? What am I drinking? I haven't had a drop of alcohol. What am I drinking? Tell me more about it, nobody. You fucking idiot. Or better yet, don't say anything at all. So this is where we start actually doing the analysis. This is where he should have started. This is where Springer's attorney should have started. Because you'll see that the court starts to go through the analysis of why a preliminary injunction should or shouldn't issue. A party seeking a preliminary injunction must establish, number one, that they're likely to succeed on the merits. You've heard this before, right? This is always where this starts. They are asking, Springer is asking for a preliminary injunction, so he's going to need to address these things. There's a substantial threat they will suffer an irreparable injury otherwise. The potential injury outweighs any harm that will result to the other side, and an injunction will not disturb the public interest. Of course, a preliminary injunction is an extraordinary remedy, yada, yada. We start off with the likelihood of success. The plaintiffs allege that federal officials ran afoul of the First Amendment by coercing and significantly encouraging social media platforms to censor disfavored speech, including by threats of adverse government action like antitrust enforcement and legal reforms. We agree. Well, I could do this all day, dude. I don't fucking care. I'm not monetized. Like, you don't have to watch me. Like, I don't gain anything by this. I do this for you, pro bono. And if you want to be a little bitch, go be a little bitch somewhere else. Like, I don't need your clicks and views. I really don't. I don't monetize. I don't make any money by this. Make sure you donate to my G-String account. But yeah, like, people think that, like, oh, you should do it this way because then you'll have more views. Like, I don't fucking care, bro. Like, have you seen me do anything that would enhance people or draw people in here, right? Like, I have roosters crowing into my microphone. I have the guinea fowl. I mean, look at my light. I don't have any of those ring lights or anything like that. I don't have any production values. You're lucky if I have the right screen up when I'm reading. You're lucky if that happens. All right. So there's two things here that you should be aware of. Coercive. He's not banned. He's just timed out. He should just be timed out. In StreamYards, I just hit timeout. I've done that before and people come back. So it's just like a 10-minute timeout or whatever. Give him time to just cool off. No, you're lucky if I don't have pants, sir and or madam. So there's two, but there are two words here that are two, I guess, terms of art here. Coercion and significantly encouraging. All right. Coercion and significantly encouraging. Those are terms of art. They have meaning. And the court now is going to define what those terms mean. The court cannot abridge free speech. A private party, on the other hand, bears no such burden. It is not ordinarily constrained by the First Amendment. That changes, though, when a private party is coerced, term 1, or significantly encouraged, term 2, by the government to such degree that its choice, which if made by the government would be unconstitutional, must in law be deemed to be that of the state. This is known as the close nexus test. So what should they have gone over? They're alleging coercion. They have alleged coercion. So what they should have gone over in the opinion that they were reading is the close nexus test. Could you? Yes, you could be. All right. Oh, you were talking about the Springer one. No. the basis of the Springer case is that there were 2 or 3 administrative orders that made it so that Springer could not go to the court unless it was on court business, i.e. business that the court conducts, not whatever business that Springer wanted to conduct. So you could only go there on court business, or if he had a hearing. So like if you went there to file something, that's court business. If you went there because he had a hearing at the court, then he could go there. But if you went there, he had to go to the sheriff and get a sheriff's escort. And so he sued the 7th Judicial District Court for those orders. Now, why the 7th Judicial District Court issued those orders is subject to some debate. Freeman contends that his actions were not in any way, shape, or form disruptive to the point where he should be punished this way. And the court, the 7th Judicial District Court, the defendants disagree. And Freeman alleges that he was not properly served these orders. He had no notice, no opportunity to be heard. The defendants have so far disagreed. So that's the crux of the case, of the Freeman case. So instead of going through the closed nexus test, the two are somewhat easily identified. The first one is the significantly encouraged. That's the first one the court goes over in this Fifth Circuit case. And significantly encouraged basically means that the state did it. Like the state said, do this, and they did it. They didn't have to threaten them with anything. They just basically made them do it. The second way is the coercion. And the coercion is really hard to figure out when it is and isn't coercive. But essentially it comes down to if you threaten someone with like fines or something like that. Like if you say like that we're gonna take away something entirely unrelated, like we're gonna take away your license to drive a car if you don't post this up on social media, right? That would be coercive. But it's surprisingly, it's not coercive if the government in New York threatens insurers with if they don't stop insuring the NRA, then or if they stop insuring the NRA, then the government would look past some of their more petty regulation violations. That's not coercive for whatever reason, but you get the idea. It's got to be really in your face. You have to be exercising a lot of control. So let's see what they allege. Yet here, these defendants are engaged in a vendetta against plaintiff, complete with the public posting of his picture with all of his relevant information that would include the information that could be used to steal his identity. See Exhibit 1. Okay, let's go to Exhibit 1. This is the declaration of James Springer. I declare that I'm a resident, yada, yada. I'm familiar with the contents of the complaint. He's familiar with all the contents of everything, apparently. They're true and correct to the best of his knowledge. Prior to receiving the administrative orders at issue, I was never given any notice that I would be deprived of my rights as a citizen journalist to enter the courthouses in the 7th Judicial District and to report on the happenings there. But what he's not saying is he wasn't served with notice. He has, because you see what he's saying there? Like, he wasn't saying I was never given notice. He's saying, I was never given notice I would be deprived of my rights as a citizen. Well, what were you given notice of? After the administrative orders were entered indefinitely against me, I have been afforded no opportunity to appeal these actions. Why not? Why weren't you? Which cut me off from speaking in an informed fashion or report on the happenings of the court in-house in a very significant and damaging fashion. Well, none of that is a real fact. What does it mean to have not been afforded? I've been afforded no opportunity to appeal. What does that mean? The court allows you to, the orders allow you to go to the court for official or for court business, i.e. to file a appeal, right? File an appeal, a notice of appeal. It allows you to go there for hearings if you have a hearing. So if you have a hearing on your appeal, right? Wouldn't one assume? So he says things, but he's not actually saying specific facts, right? On October 30, 2023, I learned that my picture and my information, what information, had been posted on the public area of the Torrance County Judicial District. What information is that? Can you read anything? And look where it is. Look where it is. Buried down deep. It's got a Kleenex box in front of it. Huh. What information? What information's there? He says, discovered my picture was in fact posted along with my name, date of birth, and the last four of my social security number, exposing me to a threat of identity theft as pictured below. Well, if your camera can't pick it up, how do you know it was, well, your name is out there, right? How do you know? How would you be able to steal someone's? A lot of places will have date of birth in the last four. Like most mugshots, a lot of mugshots anyway, will have the name, date, and last four of the social security number. It's not uncommon. But you literally cannot see any information in this picture. So, like, you can see Google. You can see that there are words, but how do you know? How does he know? On November 2nd, 2023, I learned that one of my posts was being removed by YouTube because it had been flagged as spam, deceptive practices, or a scam, as noted below. Our team, YouTube's team, not the Judicial District, Seventh Judicial District Court, yeah, it's public info, right? So if it might violate YouTube's terms of service to have your name, your date of birth, and your social last four of your social out there. But that's literally what courts deal with. I mean, maybe not everywhere, but what was that? The criminal court in Oakland. Oh, I forget the name of it. It's near Jack London Station. It's in walking distance from Jack London Station. Doesn't everybody know that court? Wiley something? Wiley Manual Courthouse. Anyway, they post, at least the last time I was there, down in the lobby, they posted all the cases, and you could find yourself on there by name, date of birth. I don't think they had the last four of your social in there. But like Kaiser's information, you can get his name, his date of birth, and the last four of his social. I got all that shit off of that Alabama website. I mean, I had to pay like $10 or some shit like that to get it. But yeah, I mean, that's just the Wile E. Coyote Acme Building of Justice. I don't know. I don't remember the name of it. It's in Oakland. It's Alameda County Superior Court, whatever. But anyway, they post they post a lot of shit out there that. Where are we at? All right, so YouTube reviewed the content. YouTube thought it violated their spam, deceptive practices, and scam policies. It doesn't say that anybody reported it. But our policy says, if an external link goes to a site that contains spam, scams, and other deceptive practices, it's not allowed on YouTube. Yeah, but there's a difference, Chaos Warden, between what the policies of YouTube are and what the in practice, real world, what courts deal with all the time. That is a court dealing with a problem person that they wanted to be able to identify. I mean, you might not like where they posted it because someone could apparently with a camera zoom into the point where they could see blurry things, but I don't think that's. I don't think the court is going to find that because you actually have to have harm in fact, not potential harm, and he's alleging potential harm, exposing me to a threat of identity theft, exposing me to a threat of what does that even mean, dude? Yeah, yeah. I mean, yeah, not really, is it? I mean, anyway. Uh, but to continue, upon information and belief. Hold on a second. Why did the font change? Oh, because he signed it. Upon information and belief. Upon information and belief. So this isn't a statement of fact. Generally speaking, what upon information and belief is that you have hearsay evidence. You don't have firsthand knowledge of this because a declaration under penalty of perjury is limited to what you know, what you have firsthand knowledge of, right? Firsthand. Like I saw this, I heard that. But upon information and belief means that you have secondhand information of it, which means that you have hearsay evidence. So and so said X, right? So that's what upon information and belief is supposed to be. And where it really helps is upon information and belief, based on this statement by this person that on this date, this time, this happened. That's where it really helps. But this is just, this is just guessing. It's not on information and belief because they would have stated the information. This is just guessing. Upon information and belief, the review that prompted action by YouTube to remove the video was initiated by 7th Judicial District employees identifying as the same and coercing YouTube to take it down by falsely flagging the video I'd made on the 1st of November that was critical of the actions of the 7th Judicial District Court. You see, so how does he know that there was a review other than the team reviewed the content, right? Okay, sure. The review that prompted action by YouTube was initiated by the 7th Judicial. What does that mean? What does that mean? Does it mean that they? Yeah, I mean, it's only YouTube thinks that that's terrible stuff. So how do they know? How do they know? What gives them any indication that which 7th Judicial District employees? How do you know they identified as 7th Judicial District employees? What did they threaten? To coerce, you have to threaten them with something. What did they threaten YouTube with? Why did they have to falsely flag it if they took it down? None of it makes sense. And he alleged elsewhere that it came back up, that he appealed it and it came back up. So but let's look at this, right? Let's look at this. Where does that even go? https g.co/KGS 9S85DM. Where does that go? They said there's a problem. It's a URL. You know what? We're gonna go. We're gonna go there. We're gonna do this. /g.co /KGS KGS /9S 85 E capital M. Survey says, that's where it took me. I did not type in Torrance County District Court. I don't know why they thought, but they had a problem. They had a problem with the URL, is what they're saying. And so anyway, that URL isn't anything terrible, but they said we had a problem. We had a problem with this URL, and he appealed it, and there you go. And then they reinstated it. Moreover, so the declaration of James Springer doesn't actually establish that it was the 7th Judicial District Court that did that, or their employees. Moreover, unhappy that he has, again, spoken critically of and reported on his government's policies and actions, defendants, wouldn't it be defendants apostrophe, because it's multiple defendants, have now sought to censor his press publication of his YouTube video and his speech. This warrants that this court should again revisit whether or not the actions of the defendants warrant, they like the word warrant, the issuance of a preliminary injunctive relief to prevent further loss of fundamental liberty, irreparable harm, previously before the court, and well as to James Springer, I hate your fucking attorney, bro. This warrants that this court should again revisit whether or not the actions of the defendants warrant the issuance of preliminary injunctive relief to prevent further loss of fundamental liberty, irreparable harm, previously before the court, and well as to consider this additional request for injunctive relief to prevent additional irreparable harms. So what he was asking there, I think what he's asking there is, I think he's asking for the court to reconsider its ruling on his prior motion for a preliminary injunction. But he doesn't ask for it up here, so that's wrong. And he has already done a motion for reconsideration. How dare you, sir? That G-Streaming account is perfectly legitimate, and that is why YouTube has never taken it down. It has been up there for years, and it is a legitimate go give to my G-Streaming account, bro, for saying such terrible things about my G-Stream. Go donate right now. Do it. there was a motion to reconsider. I know there was, because the judge granted it in part and denied it in part. Yeah, there's the expedited motion to reconsider at 36. So this was, even though he called it so there you go. Yeah, motion for reconsideration. So he has already done a motion for reconsideration on it. It is currently pending as an appeal. And yet again, he's coming back and asking for a third bite at the apple. If you name your kid Warren with the middle initial of T, you're kind of pushing him into criminal justice in some way. I don't know who you're talking about, but I will accept that as a truism. I will accept that. Facts supporting injunctive relief. So we're going to look at these facts supporting injunctive relief, and we're going to try to differentiate between what Chile argued as facts, what Chile thought were facts, and what actual attorneys think are facts. The defendants first denied plaintiff his fundamental liberties upon the basis that the content of his speech or reporting that was critical of the government caused third parties to call and complain to defendants in a matter they unilaterally deemed to be harassing. Like if I wrote all these facts down, and I wrote all the facts that Chile alleged down in his various complaints, put them all in a bag, shook them up real good, and pulled them out one at a time, I guarantee you, if you didn't know the facts of the lawsuit, you wouldn't be able to tell if it was Chile or these dipshit attorneys who are writing them. That's this. Facts. Your basic bread and butter fact. You could church it up a little bit, add a little spice to it, but your basic bread and butter fact is on this date, at this time, this person did this thing. Who, what, when, where, why, and how. Maybe without the why, because that's kind of guessing. Rogue, Springer, now Chile. So is this an anti-frauditor channel? No. I am not anti-frauditor. I am pro First Amendment, whether or not I like the person's position. Something like that. So Derek, I'm an attorney. I favor freedom of speech. I don't like the heavy-handed abuses by our government. I think most anti-frauditor channels are full of dipshits and halfwits. Herder, auditor, dumb, right? So I am not one of them. Politically speaking, my political beliefs align fairly closely with James Springer. He doesn't like it, but they do. I understand, however, that we live in a society, and men with guns will enforce the laws, and men in black robes will interpret those laws. And no matter what I like or what James Springer likes, that's the way it is. And, there may be a political solution, but I doubt it. I like the 1A, and the 1A is designed, the purpose of it is to protect speech that we don't like. And I don't like those auditors who do shit. Like, I don't like it when they go after non-government things, because the First Amendment is designed to protect you against the government. So if you're auditing a church, I don't much appreciate that, because a church isn't the First Amendment, doesn't protect you, but a church isn't subject to the First Amendment. So I don't appreciate a lot of the bad things they do. I don't like them. You know, I really don't like them going to schools, um, because for a lot of reasons I don't like it. But by the same token, they have a First Amendment right to be fucking idiots. They have a right to be stupid. As long as they don't go over the lines, then they should be fine. As long as they don't pass certain legal lines, they should be fine. Even if you don't like it. And sometimes the auditors are right and the government, it violates their First Amendment rights. Sometimes they're wrong, and the government is completely within its authority to arrest the auditor. It sometimes the auditor's right, sometimes the cops are right, and you know, Nasty does some really stupid shit. I like the guy, but he does some really stupid shit. He can't help himself. He boy's not right in the head. So that was the first fact supporting injunctive relief that wasn't a fact. Prior to the deprivation of fundamental liberties effectuated by the administrative action taken in ECF Doc number 1-1, plaintiff was afforded no notice or opportunity to be heard, and following the issuance of the administrative action, plaintiff was afforded no avenue to appeal. And again, those aren't facts. Well, the first one is plaintiff was not given notice prior to the hearing on the administrative order number 1 or whatever. Let me look at something, because I thought when did he receive these? Oh, you can't see this. Okay. So the 7th Judicial District Court mailed out the order on March 1st. And when was the order? The order was filed on February 28th. So I do have a problem. Like, if he wasn't given notice and an opportunity to be heard before he was essentially trespassed, that's kind of bad. But I don't know. But this part, plaintiff was afforded no notice or opportunity to be heard. Okay. And following the issuance of the administrative action, plaintiff was afforded no avenue of appeal. Like, what did plaintiff do? Did plaintiff actually attempt to file an appeal? Because like that would be a step to say, like, plaintiff tried to file an appeal and plaintiff was not allowed to file an appeal. Plaintiff's appeal was rejected on this ground, that ground, or the other ground. Because if you notice, there is a case number. So there was a number D-722-MS.2003-0001. So there's a case number, which indicates to me that that there's something appealable. And he's named because it's in the matter of James Allen Springer, a.k.a. James Freeman. So the order was signed or was filed on February 28th. It went into effect on March 1st. But why wasn't he afforded an appeal? why wasn't he afforded an appeal? What did he do? What did he do to see if he was or was not afforded, or if he could or could not appeal? What did he do? He doesn't say. The defendants then continue that deprivation under the false premise that plaintiff had entered the Moriarty Magistrate Courthouse for non-court business, and under the undefined and ambiguous premise that plaintiff was somehow being disruptive and threatening. Doesn't seem like a fact. And the defendants have still yet failed to provide any pre or post deprivation due process to plaintiff. Well, we'll see. We'll see. I would like to see the defendant's response, a substantive response, before I get too far into that. Currently, defendants have now changed basis in front of this court. The defendants have now changed basis in front of this court, and the court has entertained as true, despite plaintiff's well-pleaded allegations to the contrary. Well, I'm going to challenge the well-pleaded thing, that the actions to infringe upon and deprive plaintiff of fundamental rights were justified because plaintiff broke court rules and spoke in what can at worst be described as an impolite manner to a hearing officer and a court clerk. Well, can it be at worst described as an impolite manner? Uh-huh. It wasn't in this one. It was, let's see, in this one. Where was it? She talked about it in here somewhere. Maybe it was in somewhere in there. I forget where it was, but somewhere the district court talks about how maybe court staff doesn't like to be referred to as a whore. You know, maybe. Keep dreaming, sunshine. Keep dreaming. You got to buy me dinner to see my dick. Isn't that right, Nate? I really want to see it. Mm-hmm. Well, I'm going to stop looking for it. I'm going to stop looking for it. But I remember that that the judge was very very unpleased with Springer's actions. God, I wish I could remember what it was. I just said I was going to stop looking, and here I am looking. Uh, oh, here we go. Here we go. Here we go. Although it's not argued in the instant motion, plaintiff argued in his motion to reconsider the court's order denying his request for TRO preliminary injunction. The court has assumed as true the defendant's statements that Mr. Springer was harassing or caused others to unlawfully harass court staff with zero evidentiary basis. The court made no such assumption. While the court's order and amended order denied plaintiff's request for a TRO preliminary injunction characterized plaintiff's behavior at the 7th Judicial District Court as, quote, disruptive, end quote, that was the court's own observation. That was the court's own observation. That was the court's own observation based on its review of plaintiff's YouTube videos of his interactions with personnel at the 7th Judicial District Court. Videos which plaintiff provided to the court provided the court hyperlinks to, and which defendants provided the court's copies of. In one of the videos, plaintiff is sitting in the gallery of a courtroom and surreptitiously recording a hearing to which he was not a party. When the hearing officer instructs plaintiff to wear a mask per the court's rules, plaintiff becomes disruptive. This is the court saying this. When the hearing officer tells plaintiff you must either wear a mask or leave the courtroom, plaintiff announces, "Tell you what, son, I'll just get a bigger team and we'll come back, sweetheart. All right, we'll be back." In another video, plaintiff asks a court's office or clerk's office employee whether she is a prostitute and asks her how long she's been, quote, in the escort business. In the instant motion, plaintiff describes the statements he made to the clerk's office employees as, quote, humorous, end quote. Based on the court review of the video, the clerk's office employee did not appear to think being called a prostitute was humorous. Regardless, the court's characterization of plaintiff's behavior at the 7th Judicial District Court as, quote, disruptive was based on the court's review of the videos in the record, not based on the defendant's description of plaintiff's behavior. If that isn't the biggest way that we could tell that James Freeman's new motion is fucked from the start, I don't know what. Because he is saying that currently the defense had now changed basis in front of this court, that the actions to infringe upon and deprive plaintiff of fundamental liberties were justified because plaintiff broke the court rules and spoke in what can be at worst described as an implied manner. No, the court described it as disruptive. The court described it as disruptive. You dumb shit. Like, now let's go on, because we get a little footnote here. He's gonna fucking dig his grave deeper. Contrary to the beliefs of wokeism, i.e., district court, you must be woke if you think that was disruptive. The First Amendment does not only protect polite or politically correct speech, it does not provide justification for government deprivation of fundamental liberty under the Supreme Court's precedent since Cohen versus California. To walk down the Los Angeles Municipal Courthouse corridor with a jacket that said "fuck the draft," and have the Supreme Court find that Cohen could not, consistently with the First and 14th Amendments, be punished for asserting the evident position on the inutility or immorality of the draft as his jacket reflected. Well, what Cohen was dealing with was a statute in California about disruptive speech. And as we all know, most words by themselves can't be censored by the government. In order to censor, you really need to have something like, I don't know, fighting words or true threats, things of that nature. So just the word fuck by itself, which is what was important, was that the jacket had the word fuck on it. That's what he was going to get in trouble for. Now, what would have happened if Cohen had gone into a courtroom? Because the courts have also said that courts can restrict apparel. Like, the Supreme Court itself doesn't let you go in wearing any political slogans. You can't go into the Supreme Court's. Let's look it up. Let's look it up. If the Supreme Court says you can't do it, guess what? Supreme Court rules on apparel. In the courtroom. That's New Mexico. Hold on. Supreme Court of the United States. This is supremecort.gov/visiting/prohibited-items.aspx. You cannot wear or display political buttons or attire in the Supreme Court, or otherwise wear inappropriate clothing. What does that mean? I don't know. But specifically, you can't wear or display political buttons or attire. You cannot bring in electronic devices of any kind. If the Supreme Court, which is the ultimate determiner of what is or is not constitutional, if they have courtroom rules that prevent you from bringing in cameras, if they have court rules not allowing you to record in the court, if they have rules that you can't wear or display political buttons or attire in the court, then why does this dipshit try to apply a ruling on a statute that attempted to ban the word fuck when it was enforced with a guy walking down the Los Angeles Municipal Courthouse corridor, not a courtroom, corridor, and it wasn't contempt of court, it was violation of a statute. I mean, why he's trying, like, the guy does not understand. These lawyers don't, these lawyers specifically, this buffoon team that Springer's hired does not seem to understand the case law. They seem to have the same understanding of the case law that Springer has, that a sovereign citizen would have. It's kind of admirable how dumb they are. I mean, you have to go to great lengths to be able to make it through law school and pass the bar and still be this fucking incompetent. I don't know. I mean, I don't know why. I can never tell you why. I can just tell you what is, and this is a shit pleading. Now, upon information and belief, again, I don't have any actual knowledge of it, or I can't point to any hearsay. Using the authority of at least using the authority, or at least the air of authority, of the state district court, the defendants or the defendant's employees, because they don't fucking know, have coerced YouTube. Did they apply the test? No, they did not. So how the fuck do we know if it's actual coercion under the close nexus test? We don't, because fuck you. That's why. But we're just going to assert that it's coercive, right? I have not, Derek. I have not heard of fuck you, Bob, from Kent, Ohio. To moderate or remove plaintiffs' reporting materials from the platform. It looked like they tried to remove a link, or they took it down because he had a link. This censorship is directly based on the animus of the defendants towards the conduct or content of plaintiff's speech, and not because the speech specifically violated some rule regarding speech in hallways of courthouse, in the hallways of courthouse, in the hallways of courthouse, in the hallways of courthouse, or somehow incites an unlawful action by those that heard his message. I don't think that they I don't know. I don't even fuck care anymore. This is just so retarded. Plaintiff has a liberty interest in freedom of speech, freedom of the press, and to petition the government for redress that requires due process of law before he is deprived of liberty. Plaintiff, we're halfway through. We're halfway through. Plaintiff has a liberty interest in activities protected by the First Amendment to speech, press, and petitioning. There's what Brandsburg v. Hayes. There's the Hutchins versus KQED. Or yeah, there are several cases that say that the press don't have any extra rights of access. So him calling himself press in this particular instance isn't going to help him. And courts can restrict who goes in and out of them. So yeah, I'm not sure how far he's going to get on this. Banning him from courthouses, excluding him from hearings, and denying him public services most certainly runs afoul of these protections. And then citation, no citation, like 0 citations. Moreover, depriving him of that liberty with absolutely no notice or opportunity to be heard deprives him of Moreover, depriving him of that liberty with absolutely no notice or opportunity to be heard deprives him of owing procedural due process. I'm just going to scroll down through here. All right. Standards for issuance. Okay, great. So we have a citation. Kiernan versus Utah Transit Authority. All right, so you have to show irreparable harm. The injury has to outweigh the junction that outweigh the damage the injunction will cause the opposing party. It would not be adverse to public interest, and there is a substantial likelihood of success on the merits. And he's going to have to prove the substantial likelihood, because one of the things that the court has to do, let's just look it up. The court has to show FRCP 65, and 65 didn't type in because my numlock wasn't on, because I'm a dummy. All right. So preliminary injunction is with notice. Temporary restraining order is without notice. But the contents, the court has to state contents of every injunction and restraining order. Contents. It has to state the reasons specifically. It has to give the specific reasons. Case law has narrowed this to. It has to give the specific reasons why it entered. It has to state the findings of fact that the court made in order to issue it. It has to state the findings of fact. And it can't issue it on information and belief. And when there's a hearing on it, there's a hearing. The hearing can be advanced. The trial can be advanced to coincide with the hearing. But it's an evidentiary hearing. And evidence received on the motion that would be admissible at trial becomes part of the trial record and need not be repeated at trial. There is an evidentiary hearing. I can't blame their teachers, man. I don't know what happened to them, bro. But they're going to have to prove, and I believe the standard is preponderance of the evidence to get that TRO issue. They have to prove that they have a substantial likelihood of success on the merits. That's mandatory. That's one of the 4 things they have to prove. And if all they have is information and belief, well, Google took down my video for spam, and so I appealed it and they put it back up. But it was really the 7th Judicial District Court that did that. Well, how do you know that? I don't. I can't prove it. That's a real fucking problem. Like, I don't think the court is going to allow this to get to the actual hearing. I think the court is going to say that you didn't actually cite any authority for all of these things. Like, there's no citation for authority for any of this shit. There's none. There's no citation to authority for this at all. Oh, standards. All right, we got that. Now we're going to apply it. But what do? We go back to this Missouri versus Biden. The government cannot abridge free speech. Great. Right? That's a U.S. Constitution Amendment 1. A private party, on the other hand, bears no support. That change when private parties coerced or significantly encouraged by the government to such a degree that its choice, which, if made by the government, would be unconstitutional, must be deemed to be that of the state. Well, that's where I was reading, right? That's where I kind of went into. But then it went on to a test. But is he going to go run through the elements of the test? No, he's not. Where's the elements of the test? Where's the elements of the test to show that there was coercion? Justice in Biden, plaintiff here alleges the removal of his post on YouTube to be directly from flagging of the post by the defendants and their employees. In Biden, the issue is not flagging of posts by the Biden administration. It was the Biden administration going in and saying, "This is the kind of speech we need you to censor. These are the kind of posts we need you to take down." That post there, you need to take that down. Oh, well, thank you, Paige. Show your boobs. There, the Fifth Circuit acknowledged that it is censoring disfavored speakers and viewpoints on social media. The plaintiffs alleged that the defendants coerced, threatened, and pressured social media platforms to be conduct constituted irreparable harm. The plaintiffs alleged that the defendants coerced, threatened, and pressured social media platforms to be conduct constituted irreparable harm, and that established that those plaintiffs were likely to succeed on the merits. It wasn't just the allegations. They went through a lot of things to get to the point where they proved that the defendants were doing those things. Here, the circumstantial evidence, he has to prove beyond a reasonable doubt, and all he has is circumstantial evidence. The defendants are responsible for engaging in dishonest coercion. That plaintiff's post on YouTube should be removed because it was spam, a deceptive practice, or a scam, when it clearly was not. Clearly, moreover, it appears circumstantially consistent with attempts to target plaintiff by publicly posting his picture like a wanted poster with sensitive information in the courthouse in estancia. Jesus. Well, see, the one thing that protects people usually is that the attorneys have to pass the bar. Apparently, California, literally the bar exam after the one I took February of 2017, and that was the last 3-day bar exam. And in the June bar exam, or is it July? I forget which. They dropped it down to 2 days. And then what was it, like 2 years ago? They're like, oh, California has the lowest bar passage rates in the country. And so they dropped the minimum requirements to pass the California State Bar so that 2/3 of the people passed instead of 1/3. Now, just imagine the quality of attorney you're going to get now with the relaxed bar standards. It's like, you know what? We don't have enough doctors. What we should do is we should let doctors who only maim patients and not kill them. We should let them practice medicine. It's fucking stupid. And again, the evidence clearly establishes the defendant's deprived plaintiff of these fundamental liberties with zero prior notice or opportunity to present his side of the story before the deprivations occurred, and he has been provided no avenue to appeal those actions after they've been taken. These undisputed facts alone, well, are they undisputed? I don't know about that. Established that plaintiff is likely to succeed on the merits. The Supreme Court recently reiterated that citizens are entitled to procedural due process before they are deprived of liberty, saying, here, where's here? I don't know. You tell me. The specific constitutional right allegedly infringed is procedural due process. A procedural due process claim consists of 2 elements. Number 1, deprivation by a state action of a protected interest in life, liberty, or property. And 2, adequate state process. Importantly, the court has stated the procedural due process claim is not complete when the deprivation occurs. Rather, the claim is complete only if the state fails to provide due process. It is clear the plaintiff is substantially likely to succeed on this threshold claim because he was not provided with procedural due process at any point which, quote, imposes constraints on governmental decisions which deprive individuals of liberty or property interests within the meaning of the due process clause of the 5th or 14th Amendment. Well, he doesn't have a property interest in attending those court hearings, and I'm not entirely sure that he has a liberty interest in it. So you have a right to a public trial, but I don't believe that in its entirety it went down from. I think only a portion of that. That's the 6th Amendment, right? Corporation. I think the 6th is like partially incorporated. I think you're only entitled to it in a criminal case, but the court still may close the court, but there's a test that they'd have to use. Anyway, it is partially incorporated. The right to a trial is in In re Oliver. In Ray Oliver from 1947. That was when it was partially incorporated. All right. So the question is, would this be a criminal trial? But so no, another question would be does Springer have the right to attend Is that a liberty interest? And I'm not sure it is. I'm not sure it is. I'd have to research it to be clear to know for sure. It is thus clear the defendants were required to provide plaintiff the opportunity to be heard in a meaningful time and in a meaningful manner. Well, you have to show. So you have to actually show. So one of the problems is that, like, if he had done this pleading right, he would say Freeman has a, let's just say, liberty interest in being able to go to court to watch other people's hearings, and then here's the citation for that. The problem is that they don't do that. They just say, and the really irritating thing is that the last time the court denied their motion for injunctive relief is because they didn't include argument. They didn't include references to authority and argument. So imagine the party requesting say bears a burden of showing the circumstance justify the exercise of discretion, yada yada. Plaintiff's motion wholly fails to identify these factors, right? What about the close nexus test? Have they done anything to identify those factors, to apply them to the facts of the case, or otherwise analyze, address, or prove them? Indeed, plaintiff's motion, which is brief, is entirely devoid of legal or factual analysis. Like, they do this again. Like look at how the court is doing. Like, here, as such is subject to summary denial. Here's a citation. Here's another line. Here's the 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 citation. I very rarely gravel vac. And I'm never mad when I'm messing around with my fish. The complete failure to provide him with the opportunity to be heard before the depriving of his fundamental liberties showed that he was deprived of fundamental liberties. This case held that you have a fundamental liberty or a fundamental liberty interest in going to court and watching trials. Makes our actions undoubtedly constitutional. We're not going to prove it. We're just going to claim it. Fucking stupid. Plaintiff will suffer irreparable injury while loss of First Amendment freedoms, even for minimal periods. So, does he have what case says he has a First Amendment right to go to court, to go to view a trial? And the answer to your question, Paige, is no. Now, show me your titties, because you're wrong, and you should show me your titties. No, you could be not allowed to do a lot of things, and no, no. So irreparable injury, yeah. So prove that you have a First Amendment right to go to court. Prove that you have or prove that it was the court, the district court, the 7th Judicial District Court, 7th Circuit Judicial District Court, whatever the fuck it was. Prove it was them who did it, right? Banning plaintiff from a courthouse, excluding him from public hearings, and denying him public services unquestionably denies him of his ability to speak freely. Being excluded from public hearings does not deprive you of the ability to speak freely. being excluded from public hearings does not prevent you from publishing in the press. Being excluded from public hearings, especially when that exclusion allows you to attend your own hearings and allows you to go to court on court business, i.e., to file a petition or what have you, does not prevent you from petitioning your government for redress of grievances. These guys are like retarded with these arguments. Moreover, coercing YouTube, which we haven't proven, we've just alleged, to remove his posting under the false premise they were spam, blah, 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 clearly denying his plaintiff his constitutional. You have a constitutional freedom to post on YouTube, motherfucker. It's constitutional. My 1A applause on YouTube, bitches. Oh. That's so fucking stupid. This motherfucker has a First Amendment right to post on YouTube. And his post was put back up. Jesus Christ. So here's the problem. Because his post was reinstated, because his video was reinstated, it almost by caveat, or almost by definition, shows that the 7th Judicial District Court does not have enough control over YouTube to make it stay down, and they weren't able to effectively coerce YouTube into keeping it down. Moreover, deprivation of constitutionally protected rights, including the right to due process and equal protection, inexorably creates irreparable harm. When an alleged constitutional right is involved, most courts hold that no further showing of irreparable injury is necessary. Except for the fact that they've already made this allegation before and the courts rejected it. Why? Because they didn't actually show it. This part, the part about the due process and equal protection, that was in their initial. This is so stupid. There's their motion. Here's the amended order. The court's already addressed substantive and procedural due process violations. So his argument cited a legal standard governing equal protection claims, not due process claims, right? And where in this current brief has he cited any of the legal standard governing substantive due process claims or procedural due process claims for that matter? He's a fucking idiot. The fact that you process, the fact, clearly. So normally, like if you're prevented from like exercising your First Amendment rights, so reparable harm is if you can get money back. Generally speaking, that's reparable. Irreparable is if you can't get a constitutional right back. Essentially, I want to speak today and I can't speak today. Money doesn't make up for that. You can't, like, how much is that worth? Money doesn't make up for it. So, I mean, you might think money makes up for it. You might be able to place a value on it, but the court can't. So it's The fact that blah, blah, blah are burdened, if not outright denied, as they are in this case, establishes the preliminary injunction's irreparable harm standard. So did he already? I forget. Irreparable injury. The likelihood of success on the merits. Yeah, he didn't do any analysis in there. And that's the one he lost on last time, and the court never went to the other things, even though the court said in the last motion, the last order, that for the injunctive relief pending appeal, the court said that, yeah, the court would have found, it didn't have to, but it would have found all the other ones against him. Plaintiff has established both the requisite likelihood of success on the merits as well as clear irreparable injury. Well, if you have, you've certainly snuck it past me. In addition, the balance of harms tips decidedly in favor of plaintiff. In the 10th Circuit, the government's potential harm must be weighed against plaintiff's actual constitutional injury. Where the government's perception of harm is speculative, if not outright non-existent, each speculative harm cannot outweigh an injury to the due process and First Amendment rights of plaintiff who has established a substantial likelihood of success on the merits, except for the fact that the court has already found that he was disruptive. The district court has already found he was disruptive. It's not speculative. It is actual harm. Springer has already done actual harm by being disruptive in court. It's not speculative anymore. If preliminary injunctive relief is not granted and the court later finds that the challenged law impermissibly infringed constitutional rights, the plaintiff will have suffered irreparable harm. After the fact, the court will be unable to make things right. By contrast, the court grants preliminary injunctive relief and later finds against the defendant. Plaintiffs will not have suffered any hardship, except for all of the trials that Springer disrupts, which I guess that's speculative. All the clerks that he calls a whore or prostitute. Guess that's just speculative too, right? Because the defendant cannot show any sort of reasonably anticipated harm if an injunction is granted, and plaintiffs will suffer certain harm in the absence of injunctive relief because here's something dumb. The video that got taken down and reinstated was Springer publishing material while the administrative orders are in effect, with no preliminary injunction in place. He was still able to speak freely. He was still able to criticize the court. I don't know. They haven't really done a very good case. They kind of undercut their own argument by pointing out to the court that Freeman is still making videos on the 7th Judicial District Court. When plaintiffs establish the case raises constitutional issues as plaintiffs have in this case, the court should presume the balance of harm tips in their favor. But they haven't established that. They really should. They should establish that. They've alleged that, but they haven't established it. An injunction is in the public interest. Well, again, I don't know about that. You know, if he has a pattern of being disruptive in the court, you know, for all those people who just want to get their fucking case heard and go home, you know, for all those attorneys sitting there waiting just so that they can get their fucking, like, let's get this on. I'm billing my client $300 an hour just to sit here and listen to some jagoff argue with the judge over a mask mandate. Let's just fucking get it done and go home, bro. But I guess that's not in the public interest to have the timely and efficient administration of justice. I guess the old saying that justice delayed is justice denied, I guess that could go fuck itself, right? You know what? Chili actually is more entertaining than this. That was Dookie. Anyway, we're done. I'm done. This is Dookie. I had to cover this quick. I know it came out today. I had to cover it today because I don't even know. I wouldn't be surprised if the court actually issues an order on this before the defendants have an opportunity to file their opposition. I wouldn't be surprised. The court might let them file their opposition and let Freeman do another reply. It's bad, dude. It's bad. I don't know what's going on in New Mexico, but none of the attorneys have shown anything that I really would consider to be skill. Rodney Galbone. It's kind of interesting because these two yokels are these two attorneys, I should say. They are in a firm. They're the Western Agricultural Resource and Business Advocates. This attorney is in a solo practice, apparently. And then you have the same thing for the defendants. You have the Garcia Law Group with two attorneys, and then you have a third attorney who's apparently just on his own. Interesting. I wonder what's going on with that. Why no Esquire post it? Because it already says they're represented by. You don't need to put Esquire after your name. The only way you could be representing someone is if you are an attorney. So you don't have to put one. I haven't been covering the Long Island Audits Court case. No. I don't really want to learn anything more about him. I don't like watching his videos. I don't necessarily like him as a person. I don't dislike him. He rubs me the wrong way. There's people that you enjoy watching and that you don't enjoy watching, and I don't enjoy watching him, so I don't. So I'm not really. I don't want to go through all the backstory or whatever it would take me to catch up on why it's going on the way it's going on. And so yeah, so no, I have not. I've read the district court's opinion. It was kind of interesting to me that the district court interpreted the state law, but the state law I was interested that the district court would do that, but having read the state law, well, it seems pretty self-explanatory. So, yeah. Frauditors exposed. Anybody with the name Frauditor in their channel name is probably a terrible person. Anyway, that's it for tonight, folks. Thank you for watching. And thank you, Derek, for being able to take me being a little bit mean. You're probably not a bad person after all. Probably. But I won't hold my breath because everybody on the internet is a bad person, me included. Thanks for watching. Have a great day.